Hi.
Hi, Kim.
Got the girls back together again.
I know. You're not very excited about today, are you?
Am I ever? No, never. But anyway, Andrew's presenting interstate.
Yes,
So
he abandoned us.
He did? Never mind. We'll do well.
Oh, I think our episodes always do better than the ones with him anyway, so it's all good. So obviously the election has been called.
Favourite time of my life.
Well, I think Rob is very into politics, right?
So into politics, I'm really not. But anyway,
man's the same. It's not great, but exciting news for us because it looks like there will be quite a few announcements that's going to impact employment law. First one is obviously the intention to block non-competes, which is our main topic for today. But I think it's going to be an interesting couple of weeks.
It will be.
So stay tuned.
Good.
So if we talk about the first case that we have today, so that's ETU and Sydney Trains.
Yeah, so Andrew and I talked about this a few weeks ago when the Fair Work Commission suspended industrial action for a number of reasons, but obviously because it was having such a massive disruption for the Sydney train network and commuters. And now the ETU have sought to quash that suspension in the federal court.
Yeah, that's right. Yeah. And I think it's very ironic that they're trying to do so because I recall from your discussion that part of the reasons was because the union members were just acting outside of the limits.
That's right.
And they basically said, we're going to suspend this until July just so you can get your house in order, essentially. But so they've brought an appeal of that decision to suspend under Section 425. And there's a couple of things that the Fair Work Commission had to consider. So whether it was in the public interest, the length of the suspension, and also whether it's beneficial to the bargaining reps and will help them try to reach an agreement. And the full bench in the case that you previously spoke about found that the suspension was necessary because they were quite close to reaching agreement, I believe.
Yeah, that's right.
Very, very close. But the ETU has said, no, that wasn't the case, that it wasn't in the public interest. And basically in this case, the Fair Work Commission failed to consider their specific point of view because there was seven unions. But their argument made absolutely no sense because out of the 7 unions, 5 of them in the original case were all represented by the same council, including the ETU, and there was nothing in any of the evidence that they submitted that distinguished their position.
From the others,
Plus they had already considered the fact that they were close to settling, so there was no impact on bargaining representatives to suspend the suspension. So very silly case. I think Andrew put it in just to do another put down of the union.
The union.
But it's just a reminder that with appeal cases, you can only appeal what is actually discussed in it. So in this case, they were trying to raise new arguments, which you can't do in an appeal. But interesting stuff. So now on to the next case of Bait Up and Mornington Shire Council. This one yours, Kim.
Yeah, so this is not the Victorian Mornington Peninsula Shire Council. This is a Mornington Island in the Gulf of Carpentaria. So very important to make that distinction. Anyway, so an employee accepted employment on the island. It was a term of his contract that he would be required to pay the relocation expenses that the council paid for him if he resigned within the first 6 months, which he did. And one of the reasons he said that the council didn't meet their obligations under the contract. Anyway, so the council withheld his final pay and annual leave, and he's brought an application to the Queensland Industrial Relations Commission saying that you can't withhold my payments. They argued that the fact that there was a term of his contract that he signed the contract that said that he would be reliable to repay the relocation, that was sufficient. The court disagreed. And this is very similar to the provision that we have in the Fair Work Act, Section 324, which is a bit of an odd section because it says that any deduction by an employer must be authorised by the employee, but also be for the employee's benefit. Very rare that
principally
would
for
occur.
the employee's benefit. Well, I would say in these circumstances, they potentially could have been captured under that. Say if it was someone from overseas and needed help relocating to Australia. So it was something that had been negotiated between the parties, then potentially it could have met that threat. Sorry, not threat, met that element. But in this case, it was clearly more of a punitive measure.
Yeah, that's right. If they had have reached an agreement separate to the relocation expenses and the employee had signed off on that, that would have been a different situation, but there was no evidence that there was an actual agreement like that. And you can get around it. We've gotten around it, or not gotten around it, but we have had clients enter into repayment arrangements with their employees, and that's all okay because the employee signs up to it.
Yeah, so long as it's not a deduction. That's really where the restriction is. There's nothing to stop you from, say, loaning the money to an employee and entering into a loan agreement. That's worked really well. Anything like that. But one thing you absolutely can never do is deduct from someone's annual leave.
No, you can never withhold an entitlement like that.
NES entitlements are untouchable no matter what, and you will 100% lose if you try to do that. So don't do it. All right, on to the next case. So now we're going to talk about AB and Free Hearts, Free Minds. Interesting name. But it's another case around an employee versus employer.
Yeah, so jurisdictional argument for an unfair dismissal claim where we've got a US-based charity.
Yeah. Sorry, I should say not employee versus employer, employee versus contractor. Yes.
Yeah. So US-based charity, Australian-based contractor, they say. But the issue in this case, as it is with many employer versus contractor arrangements, is the amount of control that the employer had over her working arrangements.
Yeah, a very big indicia.
Yeah, and they totally dictated everything that she did, when she did it, how she did it, why she did it. And so the Commission rejected their jurisdictional argument and said, no, she's an employee.
Yeah, so it's gone ahead.
Yeah.
I think they tried in this case to mount all these other arguments and it just didn't work. So they said, we're based in the US, so that means it's not, which is not going to work. Like it is based on control. And they tried to get her to do invoices, but it was missing things like ABNs and stuff like that. So when you try to do those things and it doesn't meet the sniff test, there's a high chance that it'll be considered sham contracting, which they raise allegations of that too. So be interesting to see where this one goes, but it is so strict now, particularly with the new definitions in the Fair Work Act as to what constitutes an employee. And if you are not, if it is genuinely a contractor relationship, but it doesn't reflect that, then you are at risk anyway. So just save the confusion and just make sure your agreement and how you're administering the work is very, very clear and explicit. So now we're talking about the CFMU and programmed industrial maintenance. Kim?
Programmed.
Oh, programmed.
Or PIM.
Yeah, I was like, okay. So true.
Anyway, so we've got an interim injunction application by the union to reinstate the employment of an HSR rep. So this company had taken over the maintenance contracts at a mine and it had taken on a group of employees from those previous contractors, but on condition that they pass their 6-month probation. At the end of the 6-month probation, they terminated the HSR rep and a number of others based on performance reviews that they had undertaken.
But just at the end, right?
Yeah,
they hadn't been
right.
consistent. Yeah,
exactly. So the union sought to reinstate the HSR rep and claiming that they terminated him not because of performance but because he had raised a number of safety issues and complaints and sought a number of improvements to be made.
Yeah.
And keeping in mind this is an injunction application, so it's not the final hearing, but the court was satisfied that it was arguable that they terminated him because of his complaints being a prohibited reason.
Yep.
And because they hadn't raised any performance issues with him during the period of his probation, it didn't pass a sniff test.
Yeah, because essentially it is a reverse onus.
Yeah.
And so it's up to the employer to prove that they did not do so. It's not up to the employee to prove that the termination was because of the prohibited reason. And in this case, like you said, there was no evidence of any performance management. It was very soon after he had raised these concerns.
Yeah.
So like we always say to clients, if employees have raised concerns, you've got to make sure you separate the issue.
That's right.
So if it is a health and safety concern, address the issue, thank them for raising it, make sure you fix it, but deal with anything separately. And with performance, always need to manage it. Yeah. You can't save it to the end because then it's going to unravel the process.
Especially when, in this case, it creates a real risk of general protections. If you then turn around and try and argue performance issues and you've done nothing to manage them, it's very, very difficult to defeat the claim.
Yeah, exactly. Now on to a safety case. I feel like we're very employment heavy this
we
week.
are today. We normally have a lot more employment, or we'd have more safety normally, but we're a bit light on cases. But yet again, Nina, another forklift injury.
Yes. I think it just proves that forklifts and heavy plant and machinery are front of mind for the prosecutor. But this case was just so silly. So it involved Matolo, who had a forklift driver who sustained multiple pelvis and spine fractures, I think long-term impairment, because he was pinned between the rear of his vehicle and another forklift. And it occurred in an area where they had a traffic management system in place, but they just didn't enforce it. And I think that's probably the most important lesson from this one. The facts are very similar to many other cases, but we just did a mock court for Australian Meat Council, and it was very similar, where if you have a detailed system and you're training people on it and they're signed off as competent, that is not the be-all and end-all, especially if you are aware that people are breaking the rules and you are not enforcing it. You are just going to be, if not more liable, I would say, because then the regulator knows what should be done and has evidence, everyone's been trained. But then if they look at CCTV and your employees are constantly doing the wrong thing and you're turning a blind eye, then it's an aggravated factor. And that's what happened in this case, because they said, we have a perfect system, this was just a blind spot. And the court found, well, no, you relied on very administrative controls and just didn't enforce it. No designated exclusion zone, nothing like that. And if you do that, then obviously that doesn't meet the sniff test. I feel like that is the underlying lesson from this week.
And of course, a big hefty fine.
Yeah, $300,000 after a discount.
Yeah, significant discount.
Yeah, and it's because this incident occurred in 2022. Had it occurred recently, I think some of the officers would be on the line for sure. Yeah. Okay, on to the main topic, Kim. Do you want to run through what has happened with the election?
No.
Just what the changes are? Oh, okay, sure, I'll do it. Okay, all right, no worries. So essentially, Jim Chalmers, who is the Treasurer, has announced that from 2027, they intend, if Labor gets elected, to ban non-competes for low-income employees, which they define as anyone who makes less than the high income threshold, which is currently $175,000. So the purpose of this is because research has shown that employees who are subject to a non-compete are paid quite significantly less than similar employees who are not. In fact, I think the ACTU said that they get 4% less pay on average. And there's some very awful stories, if you read some of the submissions, of the kinds of restraints that are trying to be imposed on people. Like I read one where someone worked in aged care and the restraint said they couldn't work for any other business in the same industry in the entire world, which is just absolutely crazy. But yeah, you have these small businesses who are kind of running rampant. I've heard about hairdressers being subjected to very, very crazy non-competes and stuff like that. They can't start their own business.
Yeah, which is crazy in so many different industries. So we've just got to keep in mind the purpose of a restraint is to only protect the legitimate business interests of the company. It can't go any further than that. And so a lot of your worldwide restraint, which is totally unenforceable. And to enforce these clauses, obviously, it means going to court, and it's a very expensive process. So that's a deterrent automatically. But it also depends on the circumstances of the individual case as well, doesn't it?
Yes, you're 100% right. So I think a lot of people are concerned about, well, why is this necessary? Because the current law, which is mostly based on the common law, means that it's actually extremely hard to enforce any restraint, including non-competes. Like you said, it has to be very narrowly drafted. It can only go so far as to protect the legitimate interests of the business. The moment it steps out of it, it will be invalid, except in New South Wales, where there is legislation that allows you to read it down and people can use cascading clauses and stuff like that. But the vast majority, particularly around non-competes for low-income workers, would never be enforceable.
No.
But the problem is people just aren't aware of that, and it is really impacting competition and deterring people from finding other jobs because they're concerned. They're not aware that their employers have to go to court, that it's an expensive process. So I think it is a good idea to implement it to protect low-income workers. I think, though, where it is a legitimate concern by some businesses is the fact that the salary cap is quite high. Like, I don't necessarily consider someone who's making $175,000 a low-income employee.
No, not really.
And certain roles who are making on that salary in certain businesses might be quite senior. So we've had meat industry businesses, for example, who've had quite senior employees who have very intimate knowledge of, say, the price of cattle. And that is very, very marginal between competitors. So going to a competitor with that knowledge could very much destroy the goodwill of your previous employer.
So you're far better off in your contracts then to make sure you protect your confidential information and your intellectual property rather than trying to rely on a restraint.
I think that's got to be the key learning from this, that although this is happening and there are legitimate concerns, I don't think it is the end of the world. Like you said, if you've got good clauses in your employment contract to protect against confidential information and intellectual property, you can also use a deed, which will make it even more enforceable. And also there are protections under the Corporations Act. So sections 182 and 183 that prevents an employee from misusing their position or information they obtain. It's extended to employees, so it's not just officers, and they can't use that to benefit or gain an advantage for themselves or anyone else. So you definitely have those actions, and we have definitely helped employers pursue employees under that if they've breached it. And things like undertakings, right? You can definitely use all those things. But I think another thing is the fear that, if I don't have a non-compete, then I'm not going to be able to keep my employees. But that's so silly, because you shouldn't be trying to restrain them from leaving. You should make them want to stay, right?
Keep them happy. So things like offer them some flexibility, wherever you can, offer flexibility. If you've got the means to, offer paid parental leave. Foster really good culture at work.
Yes, exactly. The employee value proposition is probably one of your most valuable tools. And Andrew always talks about it, like, at FCW, we do not have restraints because the idea is if we make people enjoy being here, then they will just stay instead of being forced to stay. So, look, I think it's caused a lot of debate in the news, but I don't think it's going to have as much impact as everyone thinks it will be. They have, however, discussed that they might eventually make it expand to high income employees and relate to non-solicitation clauses, which I think would be more of an issue. But until that happens, let's not freak out.
Good advice. Thanks, Nina.
No worries. All right, let's go on to the case study.
Eddie was the Victorian Regional Sales Manager for Lost the Plot IT Services, or LITS. His sale performance in Victoria had dropped below the KPIs for new clients, revenue and client retention over a 3-month period, and was continuing to decline. He had 2 meetings with the CEO, Diane, and the National Sales Manager, Ivan. The meetings were amicable, with Diane and Ivan working through the data with him and discussing what support he needed. During the first meeting, Eddie was defensive and said the economy had changed, but Ivan pointed out growth in all other states. In the second meeting, Eddie pushed back harder. After leaving the meeting, he saw his doctor and submitted a medical certificate stating that he was being bullied at work and was suffering from anxiety, and he'd be off for the next 2 days. The CIO, Clancy, called Diane the next day and reported some unusual activity. He explained that Eddie had downloaded key client data to his private email account. Diane asked Clancy to check for any other history of data removal, and he came back the following day to report that after the first meeting, Eddie had also downloaded contracts with clients and financial modelling data onto a USB. Additionally, a large volume of documents from the client drive had been printed the following day, although Clancy was unable to identify which documents. The next day, Eddie returned to work and presented a medical certificate stating that he was fit to return to work, but not under the supervision of Ivan, the alleged bully. Diane arranged an immediate meeting with Eddie, with Ivan present. She outlined the allegations against him and asked for his immediate response. She also asked him to locate the documents on his computer and delete them in front of both her and Ivan. Eddie denied downloading the documents and he refused to show what was in his private account. Diane then summarily terminated his employment, handed him a letter requiring him to deliver up the information, took his computer and mobile phone, and Ivan escorted him off the premises. Diane reminded Eddie of his cascading non-compete agreement for Victoria, as well as the non-solicitation clause for any client of the business and the non-poaching clause for staff for a 12-month period. The following day, Eddie's solicitors wrote to say that Eddie accepted the repudiation of his employment contract, citing a breach of the medical certificate and wrongful termination, as the documents he sent home were not confidential and had been used to refute allegations of underperformance, not for any improper purpose. As such, the restraints fell away. That was their allegation. The solicitor indicated that a general protections claim would be filed shortly, as Eddie's termination arose from his complaint of bullying and his medical condition.
Yeah. Long one.
Yeah, it was a long one. Do you want to read the first question?
Yep. So this is also a very long question. So Eddie was paid $160,000 per year and received discretionary commissions of over $250,000 per year. Litz was part of a vigorous competition in Victoria with 5 well-known competitors, but Litz was the largest. The restraints were set out in a deed poll with the non-compete cascading for 12, 9 and then 6 months. The area was Victoria and cascaded to the 5 other competitors. The non-solicitation was for clients he had worked with in the last 12 months and the non-poaching was for a period of 12 months. Were the restraints enforceable subject to the repudiation argument?
Yeah, so I would say they were in this case because on the basis of what the problem says, they didn't go any wider than in order to protect the legitimate business interest of Litz.
Yeah, and I would say in this case, it was extremely explicit. Like it said you cannot go and work for these 5 other competitors, which means that it is just considering the impact to the business. Like oftentimes we'll see restraints where they'll just say you can't do it for any kind of business, similar business, which is way too broad. And it's cascaded down so that they can be read down. So definitely going to be valid.
Yeah.
Kim, could Eddie have made a successful workers' compensation claim prior to his termination?
I think it would have been very unlikely to succeed. We'd certainly defend that one on the basis of reasonable management action. The process wasn't perfect in that they presumably didn't invite him to bring a support person to either of the meetings, but we'd argue that given his seniority, that wasn't essential in these cases.
Yeah, and I also think one of the points, they invited him in straight away and didn't give him notice, but the breach was so significant.
Yeah, they had to.
Yeah, so that you could justify it. But no, he's done the wrong thing. Like, I think good luck trying to make that.
And there's also
claim.
the expectation of reasonable management action as well. So I think we'd be fine with that one. So Nina, was Eddie bullied by Diane and Ivan?
No, so bullying has to be like a pattern of unreasonable behaviour and has to be repetitive. I think in this case, they were just trying to manage his behaviour. I don't think any of their actions was unreasonable and they weren't targeting him for anything as much as he was trying to say that they were. Yeah. So, no, I think there would be no bullying. He wouldn't succeed in any kind of bullying claim.
No. Well, we could, again, defend a bullying claim with reasonable management action.
Exactly.
Again, couldn't we?
So was there a repudiation of Eddie's contract by Diane and Ivan, and could Eddie evade his restraints as a result?
So no, I'd say there was no repudiation of the contract. in terms of the restraints falling away, given that he lied to them about taking the documents and his refusal to identify them or destroy them, that's serious misconduct. So that would...
and it's a breach of his fiduciary duties as well.
Yeah.
So it would have torn up everything. So he's actually, I would say, repudiated his contract.
Exactly. So was the termination based on valid reason? And did Eddie fall within the unfair dismissal regime of the Fair Work Act?
So I think that if his lawyers had changed their mind and went for unfair dismissal, his salary, I think, is arguable as to whether it fell under, because if he had confirmed commissions, it probably would have put him over, because it was 250 commissions per year. And there are arguments in different cases in terms of whether it's taken into account. But assuming, say, it didn't.
They've got to be fixed.
Yes.
In this case, they're discdiscretionary. So
I missed the discretion bit. Yeah, that's a good point.
They're not guaranteed. He's not guaranteed of getting them every year. So I think he would fall within the jurisdiction, and that bonus would not be taken into account in terms of his income.
Well, I think in that case, though, they would probably... So he could file the claim, but I don't think he would succeed because there was a very valid reason for his dismissal.
Exactly.
Like we discussed before, in terms of procedural fairness, I think they did everything by the book. Things could have been better, like they always can be, but the valid reason, I think, is so serious that they would have overlooked any small procedural deficiencies. Yeah.
Agreed.
And is a person fit for work if they have a certificate that says they have the capacity to work but they can't be managed?
So it's an inherent requirement of your role that you can be managed. So if it's a legitimate thing that his doctor said he just cannot be managed, then no, he's not fit for the inherent requirements of his role. But in this case, he's claiming that Ivan is the bully.
Yeah.
So if Litz can find him employment reporting to someone new, they should be able to try and get medical evidence to say he is actually fit to do the inherent requirements of his role because he's no longer reporting to Ivan.
Oh, okay. Yeah. So long as they comply with that, then he's fit and they can still do whatever they need to. Yeah. Okay, cool.
So will Eddie succeed with his general protections claim?
No.
No. That's a big no.
No. We already discussed all the reasons why he wouldn't succeed, and so definitely not. That's it.
Yay.
We got to the end.
Okay.
All right, well...
next week I'm on annual leave, so
sorry,
it won't be me
it will
next
definitely
week.
be Andrew and either Tom or I. But give us a thumbs up so we feel better about what we did today. Bye.
Thanks, everyone. Bye.